Hi everyone, we welcome you back to our channel. This is Legal Mindset Adeba, and today we are going in for contract law 1. We are looking at a continuation of the previous topic of offer. We are looking at termination of an offer. So in our previous video, we looked at what is a valid offer, what are the contents of a valid offer. So in this one, we are going to see how that offer is terminated. I urge you to be very keen because this topic is sacrosanct and paramount to your understanding of contract law 1. So I urge you to subscribe such that we can dive in. So section 1 of the Contract Act, Cap 284, defines an offer as the willingness to do or abstain from doing anything by a person to another with a view of obtaining the assent of that other person to make any offer. So, in the layman's language, an offer is the willingness to contract made with the intention that it shall be binding on the offerer as soon as it is accepted by the offeree. When you're defining offer, you should understand the offeree, the person who accepts or rejects the offer, the offerer, the person who states the terms of the offer, and the offer itself we have just defined. So let us look at how an offer is terminated, how an offer is brought to an end. So termination of an offer means that a valid offer can be brought to an end at any time before it is accepted. When acceptance takes place, you cannot terminate that offer. Take an example. I sell you this pen, then after accepting it and you give me the money, your consideration, you come back after 2 days, you say, I never wanted it. That cannot happen. It can be only terminated if it is not yet accepted. Let us now go and dive into it. I urge you to look at section 5 of the Contract Act, Cap 284, which discusses the modes of revocation of an offer, and therein we have lapse of time, we have failure of a condition, we have death or mental illness. So let us look at lapse of time as our first form of termination of an offer. So what is lapse of time? This is where the offer is stated for a specific length of time. So when that specific length of time expires, you cannot accept it. Its limit has expired. You get? Now, let us look at the case of Ramsgate Victoria Hotel versus Montefiore, case reported in 1866. In that case, Montefiore applied for shares in Ramsgate Victoria Company, but the company never responded to his offer up to when 6 months elapsed. They replied that they accepted his offer of buying shares after 6 months. They only accepted after the shares had degraded in price. So Montefiore also refused, stating that the offer was now terminated since time had lapsed. So Ramsgate Victoria Company sued. Court held that there was no binding contract because Montefiore's offer had elapsed due to the effect of time. Now, you should put it in your mind, even if you act as a reasonable man, indeed you accept someone's offer after 6 months, that offer has already elapsed. Let us now go to another mode of termination of an offer, and we shall look at revocation. In revocation is where the offer is cancelled or withdrawn. The offer may be revoked by the offerer at any time until it is accepted. However, revocation must be communicated effectively, you must communicate to the offeree that you're revoking your offer. Maybe I'm selling this pen, but I revoke it. I say, I'm no longer selling it. That is revocation. Section 3, subsection 3 of the Contract Act Cap 284 states that revocation of an offer must be communicated to the offeree by the offerer. Now let us look at rejection. If the revocation talks about the offerer revoking his offer, but rejection talks about the offeree rejecting. Both parties are covered for. In rejection, it is the offeree who says that I'm no longer buying. I tell you, I'm selling you Natraj. You say no, for me I use Smile Wave and big pens only. I'm not buying. That is rejection. Many of you have been rejected. You have uh, you have those girls there. They have rejected you several times. Actually, even boys have rejected many girls several times. That is rejection. You tell her, I've rejected your offer. I have one already. So let us look at a counter offer. Counter offer is like we make an offer. It's like bargaining. You counter my offer. I sell this pen 1,000. For you say no, I'm buying it 500. It means you have terminated my offer of 1,000. And we are on your offer of 500. That is the counter offer. And in Hyde versus Range, the defendant offered to sell a house to the plaintiff at £950. But however, Hyde replied and said that for him he was buying it at £900 only. And Range said, I'm not selling it at 900. He rejected. But after some time, Hyde came and said, okay, I will buy it at £950 as you said. Range said, I'm no longer selling. So Hyde reported saying that you have terminated the binding contract we made. I accepted, but you're terminating it. So when they went to court held that Hyde had a mandate to accept the offer of £950 at the time Range told him, but when he brought in his price of £900, he ended the offer and there was no binding contract. Let us now look at the last one, the natural causes, death and insanity. And indeed, you cannot contract with a dead person. You cannot contract with a mentally impaired person. If the offerer dies or if the offerer becomes insane, the offer ends there and then. I thank you very much for watching Legal Mindset at the bar. Maybe to give you a summary of what we have just said. It is like determination of an offer. We talk about the things which end an offer. And I call upon you, all students who need private tutoring, who need that mentorship by seniors, to look for our numbers down the description box. Don't fear us. We shall come out. We shall reach you. We shall get for you that specific person who has knowledge over that course unit to help you. Because students with that kind of mentorship have outperformed those without such kind of mentorship. And in law school, we are after good grades. Thank you very much. This is Legal Mindset at the bar.